case briefs, and so much more. LSData's got what you're looking for.
In 1973, Monarch Accounting Supplies, Inc. sued their landlord, William Prezioso, over the unauthorized installation of a large sign on the roof of their building, which had been leased to outdoor advertising company Murphy, Inc. The case centered on the doctrine of unjust enrichment, which requires restitution if someone receives or retains property to which they are not entitled. The initial lawsuit sought an order to stop the sign installation, but Monarch Accounting Supplies and Murphy, Inc. eventually agreed to the sign after making structural changes. They also agreed that the rent from Murphy, Inc. would be held in escrow until Monarch Accounting Supplies' rights to it were determined. Subsequently, Monarch Accounting Supplies amended their claim to seek damages instead. The lower court awarded the plaintiff half of the expenses for the structural engineer and half of the rent collected by the defendant from Murphy, Inc. However, the defendant appealed this decision, arguing that the awarding of rent was improper and that the issue of roof control was unclear. The Connecticut Supreme Court found that the defendant did not have the right to lease the roof and that the plaintiff was entitled to damages for unjust enrichment based on the defendant's benefit from half the rent. However, the court acknowledged that it had erred in awarding uncollected rent and the structural engineer's expenses, resulting in a new trial limited to the issue of damages.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.